No, thanks for the opportunity to be here. This has been sort of a trip down memory lane as I was getting ready for it, and that the sort of legislative process is always interesting. This one felt more interesting, maybe even than most of them. And maybe I'll start with one aside that somewhere during the negotiations, Abe Ayash, who is the majority floor leader at the time and the sponsor of one of the siting bills, said, and I can't remember the context, but I smell shit when I see it. And it just seemed to like capture the ridiculousness of the whole conversation. And Kara Cook, who is the governor's lead in negotiating all of the details, actually put that on a little desk plate that I now have in my home office. And it makes me smile every time I see it. So sorry for starting with cuss words, but it seems appropriate. So there were a lot of drivers in terms of how this ultimately came to be. And I think there was a sense that there was an opportunity sort of with a clean energy majority in both the House and the Senate in 2023 to move something significant. And that really, I think, galvanized a lot of the advocacy community and others into terms of thinking what this could be. And it started really with what you've seen in a lot of other states, a 100% clean energy standard, an opportunity to increase the renewable standard, looking at our already best-in-class energy waste reduction or energy efficiency standards and think about what more could be done. But what quickly evolved in that conversation was a sense that if you didn't get siting right too, it really didn't matter what you put in terms of those standards. And that, I think, was maybe the key difference between some of the environmental advocates who really wanted a robust, progressive, like nation-leading clean energy standard, significant increase in the renewable standard, which had been 10% by 2015 and then 10% by 2015 and then 15% ramped up from there to go significantly larger than that, and ultimately 50% by 2030 and 60% by 2035 were the targets. But you had project developers coming in and saying, that's great, but we're having problems even without increases in standards in citing our projects. And so if you want this to mean anything more than a good press release, you really have to partner the ambition of the clean energy targets and the renewable targets with the same sort of feasibility of being able to move those projects forward in Michigan. And that, I think, led to the focus on siting. What got our attention at the commission, it's the one place where I have to look at notes today, is that as we were adjudicating the integrated resource planning process that had been put in place in 2016, and that requires us to look at a broad range of resources, both supply side and demand side, and try and optimize around what is the most reasonable and prudent, that's the legal standard in the law, means of achieving or of meeting our energy and capacity needs 5, 10, and 15 years into the future. And what we were finding is that renewables were showing up in a really significant way. That the IRPs that had been approved going into the 2023 legislation included 15,000 megawatts of solar and wind for DTE and 8,000 megawatts of solar by 2040 for consumers. So pretty significant numbers. But what we also found as we dug into the evidence of those cases is that they were actually intentionally, both utilities were actually intentionally limiting the amount of renewables that they thought they could achieve because of siting concerns. And specifically, DTE's witness in their IRP case testified, and I'm quoting here, siting has been a critical challenge for the development of new renewable energy projects. In Michigan, 45% of townships with wind ordinances have restrictions. This was evident when the company initiated a new wave of wind project prospecting in 2017. The company started with 10 possible areas, and this was quickly reduced to 4 projects due primarily to evidence of opposition. Despite tremendous focus on community engagement, the company ceased development of 3 of those 4 projects, mainly because the projects faced intense local opposition. The remaining project has been built and will go online, but nearly 4 years after the project development started, there are still permitting details to be resolved. And so what we were finding from the IRPs is that the companies didn't feel like they could get as much as would otherwise have been cost effective or reasonable, and so intentionally limited the participation of renewables, and then were struggling even with what had been approved to move forward, starting with 10 projects and only 10 projects because of challenges with local siting, narrowing that to 4, then to 1, all based on challenges with local siting, and then struggling to get that last one over the finish line. And as a regulator trying to figure out how do you do this in a way that balances cost and reliability and other things, that certainly got our attention as well. And so at the end of August, with all of this in the ether, the governor came out with what she called her what's next message. And it was a whole host of things that she wanted to get accomplished by the end of the year. But one of those, or actually 3 of them, were essentially the energy package. And siting was included in that. And then everything happened fairly quickly. There had been a lot of work around what should a clean energy standard look like, how should we think about about increasing the renewable standard, but siting really hadn't been sort of as clearly defined in what would be introduced. And that, I think, is reflected in sort of how the legislative process played out. The siting bills that ultimately became law weren't introduced until October 10th. On October 11th, I testified in committee in support of the bills. They passed a week later out of the House committee, passed the House on November 2nd, so just 3 weeks after being introduced, passed the Senate a week later, and were sent to the governor's desk. So the whole process, from introduction, committees on both the House and Senate side, House passage, Senate passage, took less than a month. And yet, for all of that, I think this is one of the rare instances, perhaps, where I shouldn't say that, particularly as a former lawmaker, but an instance where the process made the end result significantly better. I don't think that we started out with the Michigan model. That certainly wasn't what the bills as introduced looked like. But through the process and from the beginning, there was a sense that local governments needed to have a voice in the process, and a voice that was larger than the voice that they have in other areas where the Commission has infrastructure siting responsibilities. We've had responsibility since 1929 over pipelines, both on liquids and natural gas. Since 1995, we've had responsibility for siting high voltage transmission electric transmission lines, and then since the mid 2010s, we've actually had responsibility for carbon dioxide pipeline siting. And so we've done this for the better part of 100 years in some instances, but in each of those cases, local governments really haven't had a formal seat at the table. In fact, this is one of my favorite examples to use because it's sort of the most controversial. We were sued when we approved what is now Enbridge's Line 5 pipeline by a township in the Thumb area, and I'm not just mentioning the Thumb because Liesel's here, although probably, but a township in the Thumb area that had challenged our ability to cite that project. It did not have local support. In all of the other instances other than renewable project citing, the Commission has condemnation authority, and that was exercised in that instance. And it went to the Michigan Supreme Court, who ultimately found that we did, in fact, have the authority that the legislature had entrusted us with. But it is an example that locals haven't had as significant role in project citing historically, and I think the sense right from the beginning was that they needed to have a larger role here, but at the same time, not a full veto. And that, I think, is really the crux of what became Public Act 233. But I also will say that there were 2 other developments during the process that I think really were important to what came out at the end of the process. One was, again, the opportunity to leverage local expertise and hear local concerns. The idea about sort of wetlands and drainage and the role of the county drain commissioner was a really important piece as we went through this. But we also recognized that for the vast majority of townships, they were trying to do this in good faith, but some were just looking for a way to say no. And so how do you make sure that they are able to participate in the process, that we're able to get all the information that they can provide, including things where there's a lot of local knowledge that's really important to the process, but without simply finding another way to say no outside of the zoning process. And by the way, that's the whole focus that the Court of Appeals is reviewing in terms of how were implementing this, and those oral arguments, I think, happened on Wednesday of this week, and so there's still a lot going on. But that was a really important piece of it, is how do you balance local participation but without ultimately giving a veto over the project development in some other way. The other piece, and this I want to credit Representative Reggie Miller from here in Washtenaw County, who is instrumental in this. This, I think, really is the Michigan model, is that it still needs to start at the local level. And that is a different place than what a lot of other states do, where it's just like for projects of a certain size, they're cited at the state level, end of story. There's no local process. And I think this is really the heart of what makes the Michigan model unique. In most instances, other than where there's either a moratorium in place where there's clearly, they're not interested in project development, or where the local government voluntarily says, you know what, I'd rather have you do this, which is something that the townships ask through the process, because not every local government wants these huge siting fights. But in every other instance, it still has to start at the local level. And importantly, there's also a good faith assumption that when the project development process starts, the developer reaches out to the local unit of government and says, do you have an ordinance that's compatible with the state requirements? And if the township supervisor says yes, we assume that that's true. And I think and we knew that there were going to be instances where that wasn't true, but the good faith assumption that's at the heart of starting at the local level, I think, is really important for how the conversations and processes have played out. But there's also a couple of guardrails on that. If ultimately you don't have an ordinance that's compatible, there is obviously the opportunity to come to the state. You also, by saying that you have an ordinance that's compatible that ultimately turns out not to be, lose some of the intervenor compensation funding that helps locals participate in the process. And if you say that you have an ordinance that's compatible and deny a project on that basis, and then it comes to us and we approve it as consistent with the framework in Public Act 233, then going forward you have lost the assumption that you have a compatible renewable energy ordinance. And I think those are three important guardrails to make sure that there's an assumption of good faith, but ultimately it's not a blank check forever. And really, I think, changes the calculus of local governments in how am I going to engage in this process. And I think that we've seen some results. So that's essentially the framework that was passed by the legislature that is the Michigan model. And I think there's a lot of good hallmarks. But then it came to us, and we had the responsibility of implementing that. And I want to note, you'll hear from Sarah Malkoff, who leads our renewable energy and storage siting section later on, but she and her team have been instrumental in the process of implementing this. And ultimately, we provided the guidance that is the guidance that we have at this point in October of 2024. And I want to just talk about a couple of elements there, and then I'll stop and see if there are any questions. But first, as Sarah mentioned, I am a proud alum of the University of Michigan Law School, and that I think as a lawyer, I started with jurisdictional questions. So how does this get to us, and then what is our role if an application does come to us? And first, obviously, is the size. Like, you've got to be above the size demarcation points in statute. And I think that reflects that not all projects are projects of statewide significance, but larger projects are, and that's why there is a role for the state. I think that's what the legislature was thinking. But assuming that you've met the size requirements, again, there are sort of four gates that you get through. Either there's a moratorium at the local level, they send it to us directly, or in cases where it starts at the local level, either the local government takes too long, beyond the 4 months identified in statute for consideration, or they ultimately reject the proposal. And this, I think, is really the most important piece of this. There is no assumption that the state has an inherent role in siting in this process, that all projects in some way will be touched by the state. If they stay at the local level, we never see them. And that, I think, is maybe the most important piece of this, because it gets to the idea of what is a workable ordinance. And it doesn't have to be sort of every single piece of Public Act 233 in terms of the exact setbacks or nothing going beyond that. But a workable ordinance is, and it's sort of circular, but an ordinance that works. If it leads to development, I don't care if it doesn't reflect the standards of 233, because a project got built that's consistent with sort of the local priorities, but ultimately met the needs of the developer in finding a pathway to move forward. And I think that's really, really important because it gives local governments a huge amount of flexibility in negotiating with developers, in trying to find a path to yes, but on terms that are acceptable to everybody involved, without us sort of adjudicating whether in fact the ordinance is consistent with state law, or serving as some sort of appeals court or check on whether the local government did its process right. The only time that an ordinance comes to us is, again, those first two gates, but then if it gets bogged down or rejected, and then we're not reviewing even whether the local government did it right. We're just reviewing whether the ordinance that now is justly in front of us, has followed all the procedural steps, meets the standards articulated in Public Act 233. And that's a very different question than saying, like, we're reversing the local government. It's that it's gone through the local process, now it's at the state, and we're applying the standards in state statute to that project. And that's essentially where we are today. I think from the beginning, my hope was that this would change the conversation at the local level. If there is this backstop process, that it changes the conversation within planning commissions and within communities that says, if we don't do this in a constructive way, we run the risk of the ball being taken out of our hands. How do we find something that works as opposed to just falling back on saying, we don't want it? And I think there's evidence. I think you'll hear more from the next speaker, so I'm not going to step on any toes or spoil any surprises, but that is in fact what's happening. And I think it's critical that it does, because we've got fairly significant ambitions built into the Clean Energy Standard and Renewable Energy Standard. We see opportunities even on an unsubsidized basis after federal tax reform where renewable projects continue to be some of the most cost-effective options going forward. But we've got to do it in a way that works with communities and provides a pathway to siting the infrastructure that we need to keep the lights on and to keep bills affordable. And with that, I'll stop and see if there are any questions.